Welcome to the NCDWI Guide podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the NCDWI guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to episode 72 of the NCDWI Guy podcast. It's all about refusals today. We have got a month of DMV issues to discuss. The entire month of September, we are going to be going through a number of DMV related topics. Next week on episode 73, we will be discussing DWI restoration hearings. And then the following week on episode 74, we'll be talking about ignition interlock violation hearings, but we'll continue the DMV issues throughout the rest of the month. So episodes 75 and 76 as well. So today we're talking all about refusals. Going to be a great episode, deep dive into refusal related DMV issues. So excited to talk about this. Any issues on the recording end, please forgive if there's any audio issues. Anybody that is watching can see I've got the green screen effect going on in the background. I am recording this just hours before release from my home. I could call these DMV episodes the COVID quarantine episodes because my family is in quarantine, something that many people listening have experienced themselves over the past year and a half plus, but we all have to work through it. So I'm recording this episode late at night when all the critters are asleep in bed, and honestly am pumped to be talking to you. So the COVID files, the show must go on, as they say. So I'm excited to talk to you about the refusal related topics that we're going to discuss tonight. One quick favor, if you could, before we dive into today's discussion, there is a competition going on that I am a part of, the Crisp Effect Challenger competition. I have been involved in a group through the Crisp Video Company, a group of attorneys that have been documenting over the past year improvements that they've made to their office, their team, their community, and to themselves. And so I have created a video that has captured that progress or process that we have gone through as a team, that I've gone through personally over the past year. And I would greatly, greatly, greatly appreciate if you could take 10 seconds, go to the following link, and vote for my video. If you want to watch the 3.5-minute video that I put together, I would love any feedback on that front. But I'm going to be honest about it. If you just go and vote for me and don't even watch the video, cool beans. That's totally good on my end. Definitely appreciate any feedback again. But if you go to vote.crispeffect.com, that's vote.crispeffect.com, vote.crispeffect.com. And please leave me a vote. I would greatly, greatly appreciate it. So we are talking about refusal hearings, right? This is important stuff. You cannot appropriately advise a client, a DWI client, on how to handle their case if they refused chemical testing without having a very solid knowledge of the refusal license implications that are going to stem from that refusal. If you have a client that was charged with a DWI or implied consent offense and refused chemical testing, this is extremely important to have a good knowledge of, a good foundation of, so that you can communicate it. So today we're going to talk through some of the following items. What is a refusal revocation? How do you uncover this issue during a consult? What after action items do you give after the consult for somebody that tells you that they refused? When should you appeal? When should you actually file your appeal? Why should you appeal a refusal hearing, a refusal revocation rather? What would be the time frame of the appeal? And once you get finally to a refusal hearing at the DMV, then what are the issues that come out during that hearing, and what does that hearing look like? And then finally, if the hearing officer doesn't find in your favor, what appeal rights does your client have? So we are going to take a deep dive on this issue. What we are not going to be talking about, other than maybe just in the periphery, is we're not going to be talking about the refusals impact in the courtroom criminal setting. So there is a number of ramifications that would come from the person refusing chemical testing in terms of how that could be used as evidence of guilt at trial and other related issues in sentencing or otherwise. We're not going to talk about how this is going to play out in the courtroom. So that's not what we're going to be discussing. We are going to be discussing primarily, almost completely, the impact this has in the DMV setting. So buckle up, get ready for a deep dive here. This is going to be some good stuff. So our primary statute that we're looking at when it comes to a refusal revocation, DMV refusal revocation, is 20-16.2. 20-16.2 C1 talks about how the results of a refusal are going to get reported to the DMV. 20-16.2 D talks about the consequences of refusing chemical testing. It talks about the right to have a hearing in front of the DMV and what the issues are that can be presented at that hearing. Very limited number of issues under 20-16.2 D that can actually be brought out. It goes through the right to a hearing in superior court, 20-16.2 E. So these are the main items or the main statute that most of this information is drawn on. We're going to be talking about cases that deal with refusal, but the foundation for the legal framework of refusals as it relates to the DMV is going to be found primarily in 20-16.2. So what is a refusal revocation? What is a refusal revocation? Well, when there is a willful refusal of chemical testing could be blood, breath, or urine. I have never had a refusal of a urine case. I don't think I've ever had an officer actually ask my client to give a urine sample. So I'm still waiting on that one to come across the desk. So primarily this is going to be refusal of blood or breath. But whenever there is a refusal of chemical analysis, and this is not refusal of the roadside PBT, okay, that's not going to translate into a refusal analysis with the DMV. But when you have a refusal of chemical analysis of blood or breath testing, that's when these issues are going to potentially come into play. So what is it? Well, a refusal revocation is basically a revocation that comes as a result of refusing chemical testing. It results in a 1-year suspension of the person's license, and that 1 year begins on the 10th day. So under 20-16.2 D, that revocation is beginning on the 10th day following the mailing of a letter from the DMV for a period of 12 months. So the revocation is going to be for a period of 12 months. Well, when your client actually gets that letter is a giant mystery. I have had clients get letters within 30 days from the DMV indicating that their license is going to be revoked for a year for refusal. And I've had other times where it has literally been close to a year later after the charge that they get that letter. As far as I can tell, there is no rhyme or reason as to why it takes a shorter or longer period of time for a person to receive that letter. That's kind of frustrating because your client, and we're going to talk about this in a few moments, but if your client is regularly looking for that letter from the DMV, this could go on for 4 or 5 months where they are checking their mailbox literally every day waiting for this letter. And it's just kind of a headache, a anxiety provoking thing that is just hanging over their head waiting for this letter to come. So it is frustrating waiting for that. But the revocation is based on when the letter is printed by the DMV and nothing else related to the case. It's based on when that letter is printed. When can a person get a limited driving privilege? Well, if a person is otherwise eligible to get a limited driving privilege, they can get one 6 months into that 12-month period of revocation. So 6 months into the 12-month period of suspension for refusal, a person can get a limited driving privilege. What does that mean? The person, if the refusal revocation sticks or if it is not appealed, loses their license loses their driving privilege for at least 6 months. Doesn't matter if it's a first offense. So this is a really big collateral consequence of a DWI, particularly in a first offense situation where a person is convicted of the DWI, or even if they're not convicted of the DWI, the refusal revocation sticks. To have no driving privileges for 6 months is a big deal. So in a lot of consultations that I have on first offenses where there is a refusal of chemical analysis, that tends to be the biggest consequence that my client faces is a 6-month period of no driving. So again, that's why this stuff is so important, because it really could be the biggest consequence that your client faces. Is not related to anything that happens in the courtroom, not related to anything connected to the DWI charge itself in terms of the criminal context, but the collateral consequence of the refusal in terms of the impact that has on driving privileges with the Division of Motor Vehicles. So that's why this is such a big issue to kind of wrap your head around. So how do you uncover this? Well, you've got to uncover this during the consult. And like we've talked about in the past, a great DWI consult results from asking a lot of questions. So there should be questions related to chemical analysis. Obviously, what was the alcohol concentration? Did you get asked to blow on a portable breath test at the roadside? Were you asked to blow on a intoxilizer at the jail or at the detention center or at the police station? Were you asked to give a blood sample? Did you ever refuse any chemical analysis that was offered? You have to have some in-depth conversation during the consultation about whether or not there was a refusal. If there is a situation that you have and the client did not give a chemical analysis, so there was an inability, let's say, to complete breath testing, and then the person was asked to do blood, you can almost assume in that conversation with the client, if you don't have any documentation from the client in front of you, it is better to assume worst case scenario of a refusal of the breath testing, that the officer indicated that your client refused breath testing, so that you can prepare your client for how to deal with a refusal revocation coming from the DMV. So what that means is that if there is ambiguous information coming from your client about whether or not they refused any chemical testing, if there are some odd facts, again, example would be you have a person that you're on the phone with, They say, well, yeah, I was trying to blow on the breath test back at the jail. I blew 6 times. Ultimately, the officer found that I couldn't do it. And then I interject, what did the officer indicate that you refused chemical testing? Oh, no, I didn't refuse anything. Every time he asked me to blow, I blew. Do you know whether the officer believed that you were refusing? I mean, he didn't say anything of that nature to me, but he then did ask me to do a blood test, or he went and got a search warrant to draw blood. That to me raises alarm bells of this person very well may have been found to have refused by the officer, even if that wasn't clearly conveyed to the client. Now, we can obviously figure that out down the road, whether or not that actually happened. But I do want to have a conversation with my client about that during the initial consultation so that I can make sure that we don't miss anything from the DMV that we need to appeal in a timely fashion. So you want to get this uncovered during the consult. Do not wait to figure this out until weeks down the road or months down the road. That is why, this is one of the reasons why having a good consult is important. So after a consult in which you believe there is an indication that your client refused or there's ambiguous information about that, tell your client to be on the lookout for a letter from the DMV indicating that there was a refusal. And even if you're getting this from your client, I didn't refuse. I'm telling you, I didn't refuse. What I always tell my clients during that consultation, especially if it is ambiguous, they didn't specifically say, you can shove that intox breath tube, where. There's no way in heck I'm going to blow on that breath test. Even if it's not that, even if it's just I wasn't able to blow, and that's the basis of your suspicion of a potential refusal. What I tell clients is that the DMV's definition of a refusal is not the common sense understanding of a refusal. Most of us would say that you're refusing chemical testing if you tell the officer that you're not going to do that. The DMV basically believes that you're refusing a chemical test even if you're trying to perform the test, even if you're attempting to perform the test. They may view that still as a refusal. So that's how I explain it to the client, so that as they're kind of trying to say, well, no, I didn't refuse anything. Again, there's a difference between how the DMV sees a refusal and what kind of the common sense definition of refusal looks like when we're talking in terms of what a refusal means, what that language means. So tell your client after the consult that they need to be on the lookout for a letter from the DMV. They have to be on the lookout. They need to be checking their mail regularly, probably daily, to see if they get a letter from the DMV indicating that their license is going to be scheduled to be suspended for refusing chemical testing. We send an action plan to clients following a consult that is a written reiteration of much of what we've talked about during the consultation. And if we believe that there is a refusal, we put this language into that action plan. That it sounds like the officer believed that you refused, blank, either blood or breath testing. Here's what you need to be on the lookout for the DMV. Here's what we need to do if we're going to appeal a refusal suspension. You want to lay all that out in writing, because not only does that give your client the ability to actually do something about preserving their license and make sure that they have the right information, as you are giving them a ton of information during that consultation, but it's also a CYA moment on your end, because if ever down the road client says, you didn't tell me about this refusal situation and how this was going to impact things, point to the action plan. We talked about this during the action plan, be on the lookout for this, communicate that to the client immediately following that consultation, so that you put them in the driver's seat to preserve their license. So when should you appeal a refusal revocation? So let's say that your client ultimately does get a letter from the DMV, gets a letter from the DMV regarding the refusal revocation, and gets that in the mail. When do they need to appeal? Well, they have to appeal it within that 10-day time frame. Have to appeal within that 10-day time frame. Now, I have seen a couple of times in the very recent past where my client has not gotten the letter until after the actual revocation started, and the DMV has been a little bit forgiving on that front because the mail has just seemed to be running slower over the last year plus since COVID began. It just seems that the letters are not getting received until day 5, 6, 7, sometimes after day 10. And so I have seen the DMV be a little bit more forgiving on that. But for the most part, if you do not file by postmarked mail a request for a hearing, then you are going to be out of luck when it comes to requesting a hearing. The DMV is extremely strict when it comes to these timeframes and appealing these things in a timely fashion. So it's just going to be a difficult thing to appeal it after that 10-day time frame, and you're really not going to be guaranteed to get a hearing at that point. The only other option, and I used to do this a little bit more in practice. We really don't do this as much now as a firm, but this is maybe a case where there is some, kind of good, positive disagreement among the bar. If you feel differently about this, certainly I'd love to communicate with you about this. But I used to preemptively file requests for hearings. So if my client had documentation from the officer and chemical analyst that they had refused chemical testing, I would send a letter to the DMV immediately upon being retained stating that we are requesting a hearing. My client was told by the officer that he refused chemical analysis. I would send that off to the DMV, and then normally what I would get back would be within a week. I'd get a letter from the DMV that says, the DMV is not in receipt of any affidavit from the officer, from the charging officer, from the chemical analyst that a refusal revocation is in effect. We therefore are effectively ignoring your request for hearing. If the DMV ultimately does issue a refusal revocation, we will send you notice of that and you can appeal. But I always like to do that early on in practice. I like to do that preemptive request, because then I could say, well, I previously asked for a hearing with regard to this particular client, with regard to this particular issue. There's no way you can now tell me that I'm untimely in filing this request for hearing. However, there have been enough times in the past where paperwork has not either been appropriately submitted to the DMV or maybe never got submitted to the DMV at all, that clients that I believed were going to get a refusal revocation never got anything from the DMV. And so because the impact of a refusal revocation is so rough for a client, I did not kind of want to put the DMV on the awares of the fact that there was a affidavit that might exist out there related to my specific client. Again, I don't know if they would ever reach out to the specific officer or county or anything along those lines, but it was kind of just like, it's not worth, filing something that may never become an issue with the DMV. So as a result, over the last several years, we have no longer sent these preemptive letters to the DMV. Again, the primary reason for sending the preemptive letter to the DMV, even before you've received notice from the DMV revocation, is to preserve your right to appeal should there ever be a letter issued. The reason not to send that preemptive request is with the hopes that the DMV will never send that letter, and therefore you don't want to help them discover that in any way, shape, or form. So again, I think there could be healthy room for disagreement on that front, and maybe in a specific case-by-case basis, one way of moving forward over the other might make sense. But generally, as a firm rule now at our office, we request a refusal hearing only upon receipt of a letter from the DMV indicating to our client that their license is going to be suspended for refusing chemical testing. So we wait for that letter to come. Now, why should you appeal a DMV refusal hearing or refusal revocation? Why should you request a hearing for your client with the DMV when a refusal revocation letter is received? Obviously, if you think that the revocation was inappropriately entered, so if there is an actual issue that exists upon which you can attack the refusal revocation, that would make sense. Go ahead and file the appeal. We'll talk about in a minute some of the issues that can come into play. But obviously, if there's an issue with the refusal revocation or with the refusal itself that you think you could be successful in attacking at a DMV hearing, then you want to appeal. The other reason that I actually think comes into play more frequently is you appeal for purposes of timing of the suspension. So if you have a client that is potentially facing a 1-year revocation of their license for a first offense DWI, and they're also potentially going to have their license suspended by the DMV for refusing chemical testing for a year. So your client is facing the 1-year DWI conviction suspension and the 1-year refusal suspension. One of the main goals is to see if you can get those two suspensions then to run simultaneous to one another. So basically have the refusal revocation and the DMV or the DWI conviction suspension running at the same time. So even though they are both 1-year suspensions, they don't have to be served on top of each other. So if you can get them to run as close as possible to starting on the same day, then you can greatly reduce the total time frame during which your client's license would be suspended. So you can appeal the DMV refusal suspension, wait for the DWI to either be tried or to be pled, however that is going to work, wait for the DWI to resolve, and then you can always then withdraw the request for hearing on the DMV front. That if you file in writing a request with the DMV to withdraw your hearing, then 10 days from the date of that notice to the DMV that you're withdrawing your request for hearing, the DMV refusal suspension would go into play. So you can get pretty good about timing those two suspensions up if you're being proactive about it. So it could make sense to appeal the DMV refusal suspension, even if you have no reason to actually fight the refusal at a DMV hearing. Even if you're not planning to represent your client in a DMV refusal suspension hearing, you might say, and we do this frequently at the office, we're going to appeal this refusal suspension simply so that we could potentially time it up better with the DMV or with the DWI 1-year conviction suspension. So doing it for timing purposes is a really good and probably more common reason than actually appealing the refusal revocation and requesting a hearing with the intent of actually fighting the refusal revocation when the hearing rolls around. So in order to appeal this refusal revocation, you have to file with the DMV, or your client has to file with the DMV, a driver's license hearing request. That is, you can get the form on the DMV website. The form from the DMV is form HF-001. That's the driver's license hearing request form. About looks like 3 down from the top in terms of the listed types of hearings that you can request is preliminary hearing - refuse chemical test. The hearing fee is $450. If your client is indigent, they can fill out a affidavit of indigency and request that hearing fee be waived. So they can send that in. Assuming that they are not indigent, then they'd have to pay that $450 fee. Now, one of the things to note is that I believe, and this is something that you'd have to verify before you actually, I'm just going to put this out there, but I'm not 100% about the time frame of withdrawing. But I believe as long as you withdraw your request for a hearing at least 10 days ahead of the scheduled hearing date, then you can get 400 of that $450 returned. I believe it's 400 out of the 450. They keep a $50 processing fee, but you can have $400 returned. So again, in terms of filing a request for hearing solely for the purposes of timing, even if your client has to kind of front that $450 to kind of get the timing of the two suspensions to match up, as long as you withdraw that request for hearing 10 days, I believe it's 10 days, double check on that before kind of trusting me on that specific number. But I believe if it's 10 days before, you would get 400 out of the 450 back. So, that's something that might be a good option for a client that is just filing the hearing request solely to try to time up potential suspensions from the DMV or DWI conviction revocation, along with the refusal revocation. So that again is form HF-001 from the North Carolina DMV website. So let's say that you actually do appeal the refusal revocation and you request a hearing. Now you are getting set to actually have this hearing at the DMV. So 20-16.2D talks about what issues can be considered in a refusal hearing. This is what we're looking at. So whether or not the person was charged with whether or not the person that was charged with an implied consent offense or the driver had an alcohol concentration restriction on the driver's license pursuant to GS 20-19 is one of the issues. Number two, and this is one of the ones that we're going to talk about, a law enforcement officer had reasonable grounds to believe that the person had committed an implied consent offense or violated the alcohol concentration restriction on the driver's license. Number four, we're going to skip the next one because it didn't come up much. Number four, the person was notified of the person's rights as required by subsection A of 20-16.2. And finally, the person willfully refused to submit to chemical analysis. So what that basically means, let me boil this down, is that there are three primary attack points to a refusal revocation. When it comes time to have a hearing, there's three main issues that you're looking at. Number one, did the officer have probable cause to believe that your client had committed an implied consent offense at the time of requesting chemical analysis? Number one. Number two, the person, your client, was notified of their rights related to chemical analysis as required by 20-16.2. And finally, number three, the person, your client, refused to submit to a chemical analysis. Those are the three issues. So those are the issues that we are going to spend most of the rest of our time together today talking through. Did a law enforcement officer have reasonable grounds to believe that your client was driving while impaired? Did the chemical analysis properly inform your client of their rights? Did your client actually refuse to submit to chemical analysis? So, number one, reasonable grounds or probable cause to believe that an implied consent offense had been committed. Again, remember that reasonable grounds equals probable cause. So even though the statute 20-16.2 talks about reasonable grounds, the courts have found in North Carolina that that is the functional equivalent of probable cause. You can look at State versus Harris, 279 NC 307, 182 Southeastern 2nd, 364, 1971 case to basically say that DWI, or in the DWI context, reasonable grounds is the same as probable cause. So there's a good quote. So I'm not going to get too much into whether or not probable cause existed. We've talked in the past about probable cause and how you can go about attacking a case based on probable cause under North Carolina case law. However, it's important to know, and this is one of the few times today that we'll kind of talk about the relationship between a DMV refusal hearing that's happening at a DMV office as connected to what's going on the criminal case in the courthouse. If you successfully get a motion to suppress in a criminal case based on probable cause. So let's say that before your DMV hearing comes up, you are in the criminal context, you get a judge to grant a motion to suppress on your end, finding that the officer did not have probable cause to make an arrest for driving while impaired. You can use that decision to stop the DMV from being able to proceed on the refusal revocation hearing and to basically overturn the refusal revocation. So they can actually overturn that refusal revocation based on what's going on in the criminal court. So item number one on that front is that you'd have to get a written order by the district court judge or superior court judge, but likely district court judge from the courthouse that explains the reasons why probable cause wasn't met, and specifically finding that probable cause did not exist. So this has to be a specific finding that probable cause was lacking, and therefore the case was thrown out in the criminal courtroom context. If you get that order, then under Brower versus Killian's 122 NC App 685, 472 Southeastern 2nd 33, a 1996 case, Brower versus Killian's, that case basically found that if the judge finds that there was no probable cause to arrest for DWI, the DMV hearing officer is stopped from deciding whether reasonable grounds existed to believe the person had committed an implied consent offense. So that's one of the few places where there really is kind of an overlap between what's happening in the courtroom and what is happening in the DMV context side of things. So good case law for the defense on that particular issue. So a lot of times it could make sense if you have a good PC issue, if you have a good probable cause issue, it could make good sense to fight that in the district court first, so that you could use that district court result to then stop the DMV from proceeding in a refusal hearing context. Second, did the chemical analysis inform the person charged of their implied consent rights? So again, under 20-16.2, there's a number of attack points that you could use to argue that the chemical analyst did not appropriately advise the person of their rights under 20-16.2. First of all, you could argue, and I'm not going to go through all of them, but I'll go through some of the more prevalent issues that can kind of come up under this appropriate advisement. The officer has to inform your client both orally and in writing. The statute itself requires that the person be read the rights by the officer and provided a copy in writing that is specifically under 20-16.2A. And then that particular requirement for both oral and written advisement was also reviewed in State versus Lovett 119 NC App 689, a 1995 case. Timing. So when must the person be read their rights? Well, the person must be read their rights prior to chemical analysis being administered. That's pretty common sense. And normally that's what you're going to see. There's not too many times where somebody is advised of their right to submit to a chemical analysis or to refuse a chemical analysis after it's already been received. So that's not generally going to be the issue, but the person must also be charged with an implied consent offense. So in order to read the person their rights, in order for the officer to read your client his rights under 20-16.2, your client needs to be charged. Well, when is a person charged? We get that specifically from 20-16.2, and this is A1 together in parentheses. So it's not A parentheses, 1 parentheses. It's 20-16.2 in parentheses A1. So look at that for the definition of charged. And that says a person is charged if the person has been arrested for an implied consent offense or criminal process has been issued. For example, citation, arrest warrant, some sort of criminal process has been issued. Where this comes into play, and it actually comes into play quite a bit, is if there is a person that is requested to give, let's say, a blood sample at the hospital. The key question is whether that person has actually been arrested for or charged with a implied consent offense. Did they actually get a copy of the citation before they were read their rights? Because if they are not under arrest, which most of the time in the hospital they're not going to be, they have to have been issued process. So it's not enough to say to the person, I'm going to charge you with a implied consent offense crime. I'm probably going to charge you with a DWI. That's not being charged prior to the actual rights being read. The person has to have had process issued. Again, citation, arrest warrant, something. And so if there's not been a citation given, they shouldn't be getting advised of their rights at that point. So, I've seen judges go both ways on this issue in the courtroom. But I think that the DMV hearing officers are pretty keen on this issue specifically because of the requirement being so straightforward, black and white in the statute. It's very clear what it means to be charged under the statute's definition section. And so whether or not the person has been charged is a very important issue on that front. The other issue in regards to timing is that the advisement, again, must happen prior to chemical testing. As I said a couple of minutes ago, normally you don't see this happen afterwards. The one exception to that is where you see somebody getting charged and then requested to give 2 separate types of chemical analysis. So if the State versus Williams, 759 Southeastern 2nd, 350. This is a 2014 North Carolina appellate court case. This is a situation where a person refused to submit to a breath test, refused to submit to a breath test, and then subsequently was requested to submit to a blood test. Actually, I'm sorry. The person was requested to submit to a breath test, and then the officer, instead of kind of proceeding on that front, asked for the individual to submit to a blood test. So first the officer requested breath testing, and then subsequently attempted a consensual blood draw. The officer did not re-advise prior to that consensual blood draw, didn't re-advise. And so because the officer did not re-advise the person of the rights related to chemical analysis, the blood results were kept out. So same thing would apply, that you have to have a advisement occur before each type of testing. You have to have an advisement. So for some reason, how this would happen in the refusal context is, let's say that you have a client that is at the jail, is trying to blow, and you have kind of the rare officer who says, look, it appears that you're having trouble blowing on the device. I don't want to mark you down as a refusal, but would you be willing to give a blood sample? And we can go that route. If your client refused to give a blood sample at that point, and the basis of the refusal was related to the blood sample, not to the breath test, the officer would have had to have re-advised your client of their rights under 20-16.2 related to the blood sample before using that refusal to report to the DMV that a revocation was forthcoming from a refusal of chemical analysis. So that's where that's going to come into play. So there has to be an appropriate advisement of rights. Again, there are other issues that can come from that, which we won't get into here. Final issue that we'll talk about for just a minute is whether or not there was an actual willful refusal to submit to a chemical analysis. And I think when you are talking to a client that hasn't kind of said, adamantly to the officer, I'm refusing, but basically isn't giving a sufficient sample, whether that's intentional or not, just says, I never, told the officer I wasn't going to do this. They're going to be kind of stuck on this. So I think you want to kind of explain what the DMV is going to be looking at, but then at the hearing, you want to give as much credence as possible to what refusal means. So refusal is defined as, quote, the declination of a request or demand or the omission to comply with some requirement of the law as the result of a positive intention to disobey. That's from Joyner versus Garrett, one of the kind of most well-known cases dealing with refusal revocation in North Carolina. That is 279 NC 226. Again, Joyner versus Garrett, 279 NC 226, quoting Black's Law Dictionary. Etheridge versus Peters also kind of uses that similar language. Another big refusal case, that's 45 NC App 358, that was later affirmed by the North Carolina Supreme Court at 301 NC 76. Willful is defined as voluntary, intentional. That's from Black's Law Dictionary. The term, quote, willful refusal, end quote, embraces, quote, the concept of a conscious choice purposely made, end quote. That's from Joyner versus Garrett. The evidence must show the defendant was afforded all his rights as provided by NCGS 20-16.2A, and that he, quote, consciously and purposely declined the request to take the test. So it's important, I think, for the hearing officers that are going through this to get that really powerful for the defense language about what a refusal is, because the Black's Law Dictionary definition and some of the language from Joyner versus Garrett and Etheridge versus Peters very much is this. It's got to be a positive choice, a conscious and purposely declined. The declination of the request to take a test has to be conscious and purposeful by your client. So it's important to go through that language. Moreover, the elements of a willful refusal are that a willful refusal occurs, and this is straight from Etheridge versus Peters. Again, that's 269 Southeastern 2nd 133. A willful refusal occurs where a motorist, number one, is aware that he has a choice to take or refuse the test. So he's aware of the choice. Number two, he is aware of the time limit within which the choice must be made, within which he must take the test. Number three, he voluntarily elects not to take the test. And number four, knowingly permits the prescribed 30-minute time limit to expire before he elects to take the test. So those are the four elements of a willful refusal. Again, focus in on that voluntarily elects not to take the test, understands that he has a choice to take or refuse the test. But all of this voluntary information is important when you're looking at somebody that from the outside is appearing to blow on the device, and the officer trooper says, well, it looked like to me he was blown out of the side of his mouth, or, he didn't seem to be blowing very hard. He wasn't following my instructions. And there's case law that deals with those issues primarily to the detriment of the person that is being charged, or the person that has refusal, but point out these issues and point out this language in Etheridge versus Peters at the hearing. When it comes to the burden of proof at a hearing, so let's talk for a couple minutes procedurally about what's going on at a refusal hearing. And this is something you want to talk to your client and prepare your client for before you go into hearing. So we're kind of in the home stretch of today's episode, and basically what happens at a refusal hearing itself. Walk your client through what this is going to look like before you go into the DMV hearing office. So what I tell my client is, at this DMV hearing, most of the time, and I've been, I think, in probably at least 5 different locations of DMV refusal revocation hearings. I've been in a attorney conference room at a courthouse. I've been at the DMV locations. I've been at State Highway Patrol headquarters for these things. I've been at different locations for where they do these hearings. But I typically tell my client, this is not a courtroom. It's going to feel like a person's office. However, it's still formal. It's a formal proceeding, and it is recorded. The hearing is going to be recorded. So, we're not going to be able to talk in a meaningful way during the hearing. The entire hearing is going to be recorded. The first thing that the hearing officer is going to do when we go in there is she's going to put your hearing on the record. She's going to explain who you are, that I'm here with you, any of the officers that have been called by her to testify at the hearing, any witnesses that we have. All of these people are going to go kind of on the record as being present at the beginning of the hearing. He or she is then going to ask me if I have any preliminary issues to raise. And so you should raise all 3 of those preliminary issues in terms of the things that we just went through. In terms of the 3 attack points at a refusal hearing, raise all 3 of those preliminarily. Just say there wasn't probable cause, the officer didn't appropriately advise, and the my client did not willfully refuse, and that way you haven't waived any of those issues going into the hearing. If the officers are not there to testify, then you could also object to that information coming in by affidavit at that time in the particular circumstances. But we won't get too much into that at this point. But officer is going to ask right at the outset, do you have any preliminary issues, counselor, to raise before we begin the hearing? Yes, raise them. And then she's going to call the first witness, which is typically going to be either the charging officer or the chemical analyst. Sometimes there's one officer present at these hearings. Sometimes there's multiple, but she's going to call the officers to testify about where was the probable cause, what was going on at the time of the charge, was there an appropriate advisement of rights, did the person willfully refuse? Those are the issues that they're trying to get into. So basically, if that information comes the hearing officer is focusing on very narrow issues. This is not kind of a full-blown DWI trial from the hearing officer's side of things. They're looking for those specific issues that are allowed to be kind of dug into under 20-16.2 at the refusal hearing. So the hearing officer is going to ask questions first, and then you would have opportunity to then cross-examine the officers about any of those 3 specific issues. And then from that point, you can present evidence, whether that's the testimony of your client, paperwork, other witnesses. So then you would have the opportunity to present evidence. There have been times when I've gone into a hearing and not known whether or not I was going to call my client as a witness, because it's a little bit different than a DWI trial in terms of attacking or establishing some of these things. But again, you want to have this conversation with your client before you go into the hearing and say, hey, here's how things are going to roll when we go in. This is the process. States the hearing officer is going to call the officers first, and we have the opportunity to present evidence. Here's the evidence that we plan to present, if any. And then at the close of all the evidence, you would then have the opportunity to present a closing argument. And the only person giving a closing argument in a refusal hearing is the defendant or the defense attorney. And I say defendant, the respondent, who is the license, the person that is losing their license. So your client or you are the person that have the opportunity to give a closing argument. What is the burden of proof in regards to proving a refusal occurred? Well, in both the criminal courtroom and in the DMV hearing, the burden of proof is on the state. In the criminal trial, the state must prove obviously guilt beyond a reasonable doubt. In a DMV hearing, the state must prove a willful refusal occurred by a preponderance of the evidence. So it's on the state to prove a willful refusal in a DMV hearing context. Remind the hearing officer that that is the burden of proof required, and it's on the state. That comes from Powers versus Tatum, 676 Southeastern 2nd, 89, which is a 2009 case. So look to Powers versus Tatum for that specific requirement that the burden of proof is on the state. But again, remind the hearing officer, it is the state's burden of proof by preponderance of the evidence to show that a refusal occurred. So that is the basic issues that come into play during a refusal hearing, the process of a refusal. After a refusal hearing has occurred, I have generally found that the DMV hearing officer will not announce their decision at the end of the hearing. There's been a couple of exceptions to that, but for the most part, and this is from a number of different hearing officers that I've appeared in front of, generally the DMV hearing officer will not issue a decision at the end of the hearing. They will basically tell you that they'll notify you of the decision, and they'll tell this to your client as well, notify you of their decision in mail. And so you typically will get that either by email or regular mail several days after the hearing. The hearing officer is supposed to give written findings of fact as to why they are revoking a license, if they are going to go that route. So as to why they are going to uphold a refusal suspension, or if they are going to overturn the refusal revocation, then they will explain why they are going that route and why they're not going to enforce the refusal revocation. So they'll have findings of fact, conclusions of law. From the point that the findings of fact have been received and the kind of notification of the refusal is sustained, a person can request in writing in Superior Court, in the county in which this happened, in Superior Court. 30 days is the appeal time frame to appeal the refusal hearing officer's decision to a Superior Court judge. So basically, the Superior Court would be the appropriate place of filing. The review of the hearing officer's decision for the Superior Court judge is limited to whether the evidence in the record supported the hearing officer's findings of fact and conclusions of law. And that's it. So the Superior Court judge, if you appeal a refusal revocation that is upheld by a hearing officer, if you appeal that, the Superior Court judge is basically acting as the court of appeals. They listen to the record and they decide whether or not the findings of fact and the conclusions of law are supported by the record, and that's it. So that is effectively kind of the different ways that you can appeal. The only other kind of practical point that is helpful potentially is that The one benefit of having a refusal hearing ahead of trial, in terms of a criminal context, and this is the only other time we'll talk about criminal context, and this is our last item of today's episode, but here's a helpful tip. If you have a hearing that happens with the DMV ahead of your criminal trial, you can basically use that hearing as an opportunity to depose the officer, because everything is on the record. So you can get a copy of the transcript of the hearing. You can get a copy of that will basically have the full the full-blown hearing on there in terms of everything that was said during the refusal hearing, all the testimony that was given, the closing argument that was given, all of that. So if you have the hearing with the DMV occur before your criminal trial, then it may make sense, and this is not going to be the case in all situations, but it may make sense to use that as an opportunity to depose the officer and get them locked in, because in that context, again, there's very limited issues that are really important to the hearing itself. And the hearing officer is really looking for very limited information to support the refusal revocation, or to determine whether that refusal revocation was appropriate. You don't have a district attorney in that DMV hearing looking to kind of rehabilitate the officer's testimony or ask further questions. So if you can lock the charging officer or the chemical analyst into a kind of specific framework in the DMV hearing, you can then use that testimony, which is given under oath, as a means of being able to impeach or to kind of lock in the officer's testimony in the courtroom at a later criminal trial. So it can be very powerful in terms of having an opportunity to depose the officer without really anybody kind of sitting on the table that's trying to rehabilitate that testimony. So again, may not be the appropriate or helpful means of going forward in every case, but could be something that would be worthwhile given the specifics of a particular client situation. So we made it through refusal hearings, DMV refusal hearings, a lot of information thrown at you. We have put out a post on refusal hearings in the past that have all the cases that I referenced today. I believe we titled the post "Attacking a License Revocation for a Willful Refusal." So if you look up willful refusal, Minnick law, or attacking a license revocation for a willful refusal, if you Google search those things, that particular blog post should come up, and you'll get all of those case references for you. But again, we will continue the quarantine file, so to speak, for the next couple of weeks. We will continue to walk through these DMV related issues over the next few weeks, and I look forward to speaking with you again next time. If you found the information in this podcast to be valuable, I simply ask that you pay it forward and share this podcast with another member of the legal community. Also, if you would leave us a rating or a review on whatever platform you are listening on, I would greatly appreciate it.